Hi guys, it's Kathy. I hope you're doing well. So, this trial that I've showed you, and I didn't get all of it, but it's a way bigger deal than you think it is. I have so much to tell you, and today I finally get to tell you everything. And just excuse the eye. I can't help it. There's nothing I can do to help it. It just, I think this is how I went to my job interview today. Try not to swear. But whatever, Anyway, focus on the trial. It's a big deal. It's a great big deal. And I get to tell you why as soon as we get through the rest of this video, which is, let me share my screen. I wish the stuff on my phone would have not screwed me like that. But so we don't have closing statements, but that's okay. We've seen a lot. So we're here. We have until here. So this is going to be a pretty short stream, actually. I'm going to go back just a little bit further because we were actually here. And then I get to tell you the end. I don't know. That's not true. I don't know if anybody looked up the end or not, but don't do it now. You're almost there. You're almost there. Don't do it yet. But then we get to tell you how and why it's such a big deal. And poor Maria is powerless. I hate when people come to fix something and make it worse. I hate that. Yeah, Linus. Linus, what did you do to my eye? That's not a biscuit. Anyway, today we're going to find out what happens. Today, the wife is going to find out. I will tell you this. I'll tell you this much. She did turn down the offer to settle of, I think it was $6.7 million, $6.9 million. They offered her to settle this case out of court. All right, let's hope we have sound.
Units into place.
We
What
do.
does that mean to you?
They're determining how they're going to do it. They're determining their means and methods.
Who is they?
Way,
Who it was?
like Hembling.
Okay, and that indicate to you who will be in control of the fourth floor?
It is. They've determined how it's going to be done, and they're going to use their people to do it.
And did we learn through the course of this case and everything you've seen up to date, who was responsible for putting up some of the chain falls?
The chain falls?
Yes, sir.
TNT attached chain falls
Okay, and that would have been where, on the ground or on the fourth floor?
down on the ground level.
And who was responsible for releasing the chain falls on the fourth floor?
That was Way.
I also want to tell you, since we can see all this, that I didn't realize until today. Most of the people sitting over here were all lawyers on this case for TNT. There was an extremely large amount of lawyers. Oops. We're going to find out at the end because I just can't remember. It was like 20, 30, 40 lawyers all worked on this case over here. So all these guys are lawyers.
And who was responsible to skate the units into place?
That was Way.
Who chose the skates?
Way.
Who chose the wood on top of the skates?
Way.
Who chose to send people down that morning and cut up the wood that would be used on top of the skates?
Way.
Why did they do so?
Because Byrne put the curb in, and it created a kind of an obstruction, so they had to get the unit elevated above it.
Is there any other correspondence or any other discussion that you've seen that would show that Way Mechanical backed off its position that it was going to take care of the fourth floor?
No.
Why did Way Mechanical choose its own personnel to handle the unrigging of the unit on the fourth floor?
Why did they do it?
Yeah.
I can't tell you.
Do you know who was responsible for placing Mr. Juan Garcia as a signal person at his location on the fourth floor?
Yes.
Who?
Mr. Lurie.
How do you know that?
Through the deposition testimony.
Now, Your Honor, can we approach?
Yes. Claims counsel.
Did you do an animation in this case?
Yes, we had one done by Digital Imaging Group.
And how did you do the animation in this case?
After I completed my analysis of the evidence and had developed a theory on the cause of the incident, I instructed the digital imaging guys how to develop the animation and what dimensions to put in, how to verify the dimensions, and how the piece would move and where to place the personnel.
Is the animation that you did a visualization of your opinions?
It is.
Do the animations fairly and accurately reflect what they purport to reflect?
Yes.
Do they fairly and accurately reflect what the available evidence shows?
Yes.
Can you explain what you mean by that?
So an example is the building itself. So we have photographs of the building taken from outside. And when the animators develop the animation, one of the things in the process is that they have to build a 3D model in a computer drafting program. And then once they develop that model, we overlay the photographs on top of the animation and verify that the dimensions are correct. It's a process called photogrammetry. But basically they just do it with a computer, and we make sure that all the dimensions are right. And the movements are based off of a summary of the witness testimony. And that's how we develop the animation.
Do the animations assist the jury in understanding the testimonial and documentary evidence in a concise and easy to understand format?
Yes.
Your Honor, moved for use from a demonstrative standpoint, although not admission of the invitation.
May we approach? Yes. You know, you have effort because you can't. So, don't you? This notion is this in your intervention, which you just what's the mission for rules and so the emotions must live your own. There's no way we all know it's not true that we should develop something. He said, actually, I want to ask whether yes, all of those things. There was if you can get something, it just it is great to talk to you. That's not, I wouldn't suggest, that's a option we did. We expected that. You could expect for often faith, penetration, and it's appropriate that it's not substantially, I think, supported this. had case. And it supports the introduction of this animation. Just for the case that it's looked at, if you look at page 7. This case just keeps this section. I think he's got it highlighted. The first page that's highlighted tells you why that his animation doesn't meet the standard. Look here, it says second. The component of computer animation. And show me the stuff that otherwise. Just only the things that shows you that this animation is not secure. There's the investment that you rely on south the states. There's the issue. There's only so it's too soft. It's fair. They're only a in this trial. They're only deposition. Where it says computer is this general persons that underline or the an expert's theory of how an action occurred. Everything Mr. Bunkley is talking about is correct cross-examination.
But so you keep saying that that's not going to make me let it in the cross examination that it gets the cost. And so now it hinges upon a question of where is it at the evidence, our testimony, or deposition about that the skates are the issue. Okay, you can lay the foundation. You have to lay the foundation because you have not. I have not heard any testimony about the wood and the skates. All right. So at this time, it's not admitted. At this time, it's not admitted, but you do the opportunity to lay the foundation. Do you want this? Not right now.
Mr. Gardner, with respect to your animation, can you tell this jury everything that you reviewed in preparing the animation?
Well, I reviewed all the documents in the case. I reviewed all the deposition testimony, and I also reviewed the affidavit of Francisco Montelongo that specifically addresses that he viewed the animation and indicated that the skates were in the animation as they were at the site.
Did Mr. Montelongo indicate that the wood was present?
Yes.
On top of the skates?
On top of the skates, yes.
Did you see, what else did you review in preparation of this animation?
I reviewed all the deposition testimony.
Do you feel that this, based upon everything that you reviewed, that this animation would demonstrate for the jury the general principles that underlie your opinions?
I do.
And do you feel that this animation, based upon everything you've reviewed and the creation of such, would depict your theory of how the accident occurred?
It does.
Your Honor, move to be able to use the animation as a demonstrative.
Yes. This is awesome. I'm not interested. What's the percentage? Because it's very clear. Maybe I think the key point is supposed to be secure, not testing. But it's Anyway, this is so not. You need. It's the problem. This is just what regulates us. You know, it's just. This is what I'm looking for. Any evidence that talks about the skates and the wound. Admitted into evidence, any depositions, where is that? No, he didn't.
I'll ask you.
He's had to point that out. He can't just say that. It's not, because it's not true. I haven't heard any testimony or seen any exhibits about it. So you're gonna have to get there. And in this case, I get the animation and being used as a demonstrative, but specifically. So and specifically, this is the part that stood out to me. I have to consider whether the exhibit is a fair and accurate portrayal of what it purports or claims to be. And so there hasn't been any testimony about what your demonstrative is going to show is my position. So that's what I'm looking for. All right. Thank you. You need the water? You need a bathroom? You said bathroom or water? I can't hear you. Okay. We need a 5-minute break, deputy. If, yeah, 5 minutes only.
All rise.
What line?
What's in the cafeteria today? I mean, it might be a good day to go to the hospital. They might have good food today.
Miss Lex. You good to go?
Thank you.
Is you ready to go?
Yes, Your Honor.
Perfect. I'm missing 2 people. I'll be right back. You guys can be seated. Then I pick it up. Okay, so I'm just letting you know, you got 20 minutes and then just find a good stop place for 5.
Couple of things, phone recording, we stop now, I can cut at least an hour out of his testimony over that, save the court time. Let me lay this break.
That's a guarantee.
Yes, but let me lay this break for you first, and let's get the animation issue resolved one way or the other.
Okay.
All rise.
Ladies, you can proceed with your direct defense.
Thank you. Mr. Gardner, you've heard the testimony and trial of this case, Mr. Francisco Montalongo.
I have.
And who was Mr. Montalongo?
He was a pipe fitter with Way.
And at the time of this incident on September 22nd, 2021, where was he at the accident site?
He was right at the edge of the building and at the corner of the AHU, the air handler, right in the direction that it fell.
Your Honor, may I press the witness?
Yes, sir.
Let me show you what's been highlighted from his trial testimony and bracketed from his trial testimony and ask if you recall hearing that.
Which part, please, I just want a page line, please.
From, part of it is from his depo that was played as a cut on page 166, line 13 through 20. And then in the trial transcript, it is on Mr. Montalongo's testimony, 177, line 8 through 17, and 178, 6 through 9.
Okay.
Do you
We'll read this too. Yes.
Is that the testimony that you heard in this case, in this courtroom in front of this jury?
Yes, it is.
And did you hear Mr. Montalongo testify when asked? And then it says, cut some wood to put on top of the skates. Did you see that?
I did.
He answered, yes, ma'am, right?
Yes.
And why in the world were you cutting wood to put on top of the skates? Answer, because on the edge of the building, they put up some platform and that was obstructing the, I guess, entrance of it. In other words, the edge of the building wasn't straight flat. It had like a little obstruction, I want to call it, what do you call on the side of the road, the question curve? Answer, yeah, curve, right?
That's correct.
He also testified when asked, okay, well, do you recall that the unit had been placed on all 4 skates? Do you recall that? And he answered, I recall that. I remember we had to bump it up so I could fix the wheels on the skate, correct? You heard that?
Yes.
And what was wrong with the wheels on the skate? He answered, they were facing sideways, right?
Yes.
And so these skates did not have locking wheels on them. And he answered no, right?
That's correct.
And then he was asked, when the unit was flown in for the second time, was there wood stacked on top of these skates to get past the barrier on the perimeter wall? And he answered yes, right?
That's correct.
Your Honor, you want us to approach? I would move for the introduction as a demonstrative only of the animation.
Yes.
Okay.
Causing this to be the spirit of the city. Just is the same emotion.
Allow it as a predicate.
Come on, people. Let's go.
Then Blake, you can proceed.
Your Honor, this.
Are you opposed to ending for the day?
Yeah, promise.
We don't know. Right. Deputy Perry, can you take the jury out? We're gonna be excused for the day. Before you leave, I do want to reiterate, please do not do any independent research on your own about this case. Do not discuss this case with anyone or each other until you go into deliberations. Tomorrow, don't forget, we're going to begin at 11 a.m.
I really, really, really thought there was more. We're done. We made it to the end of all I got on this trial. So let's look at what Anthony Busby said about this trial on Instagram. Find out what happened. All right. A fine man, David Lurie, died at a construction site in Texas A&M in February 2021. So I'm not going to read this whole thing. 2 weeks after a funeral, David Lurie went and spoke with the wife and said that he would help. They mock tried the case twice. Not 100% sure what they did there, but that might have been where all those depositions were coming from that we were watching. They mock tried it twice, and he didn't do well. They weren't winning. So they were offered $6.9 million, and then it was $9 million. So it looks like previously. So it looks like it was $9 million. Then they mock tried it twice, and they dropped it down to $6.9 million. And the wife said no. Well, actually, more likely, this man said no. We're not taking that. So 3 weeks of trial, and they were awarded $160 million. And then the next day, the jury came back and gave them $480 more million for this case. $640 million is what she won. I wonder how much he gets. I don't know. It doesn't matter. This was the largest payout in Texas history, this case. This attorney is like, he's a big deal, guys. We just watched this attorney, and we don't get to see this type of attorney hardly ever on our little court channels, but this guy is a big deal. So here's an article CNN wrote about him, and I can't wait to show you the very first sentence. Hold on. I shouldn't have scrolled down so far. I was just preparing. Mean, obsessed, brash, psycho. And that's what his friends call him. We pretty much called him that the whole trial. He's such an ass. Yep, he was the one. He filed 20 lawsuits against Diddy. But what happened in that case was he is licensed in New York as well as Texas. Okay? But this is a federal case. So because it's a federal case, he had to withdraw from the Diddy trial because his license doesn't cover that. Okay, I'm going to get to that, Chinny. While he was suing Diddy for these horrific crimes. Jay-Z became involved with at least one of the girls. She was 13 at the time Jay-Z met her. So Busby put a lawsuit against Jay-Z, tried to pull him into the Diddy saga. And Jay-Z is suing him back. And what they're saying is this 13-year-old Busby tried to make her say things that happened that weren't really true. Busby disagrees. He says, no, I didn't. I don't need to do that. I don't need people to lie. We don't pressure people, he said. I don't know how much I believe that because he's an ass, but yeah. This is him on his private jet, lawsuit air. He's very humble. He's very humble, this man. This is a World War II tank that he owns. Just because he can buy it, he bought it. But he was in a lot of large lawsuits, some with deaths, like right here, Deshaun Watson, some with celebrities and football players and things like that. He was even in a criminal lawsuit once that he lost, I think. Hold on, I'm gonna get there. Oh, I plan on showing another one of his trials, but not anytime soon. Like, we need a break from trials for a while. We need to get back to, our tiny little lawyers. But here, so he represented a man, Grossman, in a hit and run. Grossman, I don't know, ran over 2 people or something in his car, and he lost, and he was sentenced to 15 years. So hold on, there's just a little bit. I think I have one more thing. Yeah, this is the day it was awarded. It's a news it's a newspaper, but not really a newspaper. It's like the Sun or the Star. I think this is something like that. I don't think this is like an actual newspaper. But they wrote a story about they reported exactly what happened. And I just thought we'd end on this picture. David Lurie, poor guy. Yeah, tabloid. That's the word. But we just watched an attorney that we're probably not going to see much trials like that. But that was the biggest award in Texas's history, what we just watched for the last couple weeks. Or a week, or I don't know, whenever we started this stupid thing. I just feel like, you know what? If you give me a minute, I'm going to go grab another. It's too soon to stop. If you give me a minute, I'm going to go, well, wait, I have Cristofino down here. Hold on. Let's watch Cristofino. I like how he started. Cristofino was this one. Yeah. I think it's this guy right here. He might be a minor. Is he still a minor? I don't remember if this guy is an adult yet or still a minor. But we'll move on to Cristofino. We haven't seen Cristofino in a while, and I love Cristofino. Let's see. There he is.
Pursuit. Even failure to comply with eventually tells me I'm.
Okay, good enough.
Yeah, there's hearsay of a deceased victim on the original officer's body cam that I want on there.
20 CO1 2409 F335 State of Indiana versus Caleb D. Goodwin Mr. Goodwin, raise your right hand, please. Do you swear or affirm under the pains and penalties of perjury that the testimony you're about to give will be the truth?
Yeah.
State your name for the record.
Not a minor because of his tattoos. Gotta be 18.
Go.
Thank you. Put your hand down now. Show the defendant in court in person from the Elkhart County Correctional Facility. By WebEx and by his attorney, Michael Bannick.
Okay, you hear a woman whispering the whole time. I think it's Kathleen Clays. I'm not 100% sure. I think that she is training someone. Again, I'm not 100% sure, but she does whisper the whole time.
In court by Deputy Prosecuting Attorneys Kathleen Clays and Lucas Shoemake. Mr. Goodwin, you come on for sentencing, having pled guilty to count 1 armed robbery, a level 3 felony, and count 2 armed robbery, a level 3 felony. Is that your understanding?
Yes, Your Honor.
Credit time will be 75%. That means you have to serve 3 days in jail to get 1 day of good time credit. Do you understand that?
Yes, Your Honor.
Any questions about credit time law?
No, Your Honor.
Do you understand you waived your right to appeal your conviction and sentence in this case?
Yes, Your Honor.
There is a split in the districts, Mr. Goodwin, and one district may believe or may have held that you have a right to appeal the discretionary part of your sentence. Since part of the sentence is left up to my discretion, I'm going to give you what is commonly referred to as your Rule 11 rights relative to appeal. I want to be clear. I don't think you have that right. I think you have waived it. But if the Supreme Court eventually tells me I'm wrong, you would have that right. In order to appeal the sentence in this case, you must file either a notice of appeal or a motion to correct error within 30 days of the date of sentencing. That's today. If you elect to file a motion to correct error, you must file your notice of appeal within 30 days of an adverse ruling on that motion. Failure to comply with these requirements will result in the forfeiture of your right to appeal. You have the right to be represented by counsel at all stages of these proceedings, including any appeal which you may wish to pursue. If you're unable to afford an attorney, I'm obligated to appoint one to represent you at no cost to you. Mr. Goodwin, do you understand your Rule 11 rights?
Yes, Your Honor.
Did you review the pre-sentence investigation report?
Yes, Your Honor.
Did you review it with your attorney, Mr. Bannick?
Yes, Your Honor.
Mr. Bannick, any amendments?
None that I'm aware of, Your Honor.
Ms. Clays, you got this one?
I do.
Ms. Clays, any amendments?
No, thank you.
Pre-sentence investigation report is approved as filed. Mr. Bannick, argument, go ahead.
Thank you. Your Honor, as you're aware, there were several other defendants who were involved in the same matter, all of whom were young. Mr. Goodwin is still 18 years of age. This case is not a juvenile court type of case, which is why he is here in adult court and in adult jail. Mr. Goodwin, his case has taken a little bit longer than some of the others, and that's not because he has ever indicated to me he wants to fight this or go to trial or anything along those lines. The delay has simply been because he's been at the juvenile detention center in Logansport, and because of communication issues. That's really the only reason for that. He is a very young man. While he was in juvenile detention, he was only brought over here 2 weeks ago. While he was in juvenile detention, he made good use of his time. He did some outpatient or intensive outpatient classes for substance abuse, did a relapse prevention program and aftercare. He has obtained several welding certificates while he was there. And most importantly, in my mind, or equally important, I should say, he did obtain his high school diploma while he was in the juvenile facility. Although he's only got 14 days of credit time, actual days of credit time against this case, he has been off the streets, so to speak, since September 13th. Of course, part of that time was most of that time was at the juvenile detention center. Looking at his juvenile record, which is before the court, it's clear that he has struggled with authority. He's had a less than ideal upbringing, which involved some family members. His male figures in his life died. His father died while he was very young. His stepfather died. while he was a teenager. He's had some family history of substance abuse, and unfortunately that carries through sometimes, and it did in this case, where he has acknowledged that he has used marijuana. He has
Wife won $640 million, JK. $640 million. It was the biggest win in Texas history.
not been a regular, but recreational use of Xanax and ecstasy. And I point that out, not because it's a positive thing in his life, but rather because I'm going to be arguing for RWI. And this is a pattern, a family pattern that has continued on, and he knows it needs to stop.
No, Anthony Lurie. Nope. Anthony Busby said in one of his tweets about it, I was reading his tweets about it, that the wife is probably never going to see that money ever, but at least they won. But it doesn't matter because she's never going to see it.
While as a youth, still a youth, he's been diagnosed with ADHD. He's been he's had some acute hospitalizations as a youth. He's been placed in residential placement and group homes. He also suffers from and diagnosed with depression, anxiety, disruptive dysregulation, mood disorder. Never heard of that one before. And PTSD because of some of the things that he observed as a youth. He advises me this was not some thought out, planned activity where they sat around for weeks and decided this is what we're going to do. It was very impulsive and foolishly, and he realizes how foolish and how much it changed his life. He went along with the whole deal, was not the ringleader, but nonetheless, he was an active participant. He has indicated to me on multiple occasions that he is very, very grateful that although they had guns, which increases the danger of this whole thing dramatically, he's very grateful no one squeezed the trigger because we'd have been in a whole different situation.
So in case you missed what happened with this little boy here, I think he's 18 now. I think he's being tried as an adult. I think because he is an adult now, but I think when he did this, he was not an adult. He terrorized drug dealers. He traumatized drug dealers in this. It wasn't just a simple, from what I understand, this wasn't just a simple robbery. He was robbing drug dealers, but he traumatized these people more than just pointing a gun at them and saying, give me the money.
If that had occurred, he has expressed to me that he can't believe how foolish and dangerous his actions were on that moment, on the spur of the moment. I think you're aware from some of the other cases that purportedly the original story from the victims, and they are victims, was that they were coming over to help somebody move, and that wasn't the situation here. They were here the victims were here, not minimizing, but they were there to sell drugs. And as everybody knows, drug dealers carry lots and lots of cash and lots of drugs, so they're good victims, is of course the thought process. They are victims, and I'm not minimizing that, but this wasn't some generous offer on the part of the victims to come help people move, which is what was originally the story that the victims put out there. Not minimizing, though, this was a terrible experience for the victims. Could have been a lot worse. The plea agreement allows you to determine within a 7-year executed cap whether these are going to be concurrent or consecutive. Of course, Mr. Goodwin is requesting that this be a concurrent sentence. That's strictly up to your discretion. We understand that. We would like it to take into account, again, some of his mental health and substance abuse issues and the fact that he had.
I love when they do that. Did you see? I'm going to go back 10 seconds. Watch right up here, right here. Ready?
Be up to your discretion. We understand that. We would like to take into account, again, some of his mental health.
That's me.
Substance abuse
That
issues,
number one. I'm the only
and
one
fact that
watching.
He had a pretty strange upbringing at various times. We would ask the court to accept the plea, of course, and we would ask the court to consider, which is something he truly needs, is to be involved in treatment, which is what we're requesting is RWI in this case. I believe that Caleb would like to address you himself, but those are my comments.
That'll be the end. And
I'm sorry.
Mr. Goodwin can address me at the end.
Right.
And Mr. Bannick, I want to be clear, in all of the other cases of co-defendants of Mr. Goodwin, what I found was what you argued today, not that this was some moving party gone awry.
Right.
It was, it was a drug transaction, and let's leave it at that.
It was.
Okay. Ms. Clays, argument, please.
Thank you, Your Honor. The state is requesting on each count an executed sentence of 7 years to be served at the Indiana Department of Correction, consecutive to each other, followed by a period of probation deemed appropriate by the court. The state
DOC.
recognizes, Your Honor, that in the case of Mr. Goodwin, along with all of his co-defendants, and appreciates that all of them have taken responsibility for their actions. They have done that in a very timely manner, which is always beneficial for the victims of crimes like this. And so the state does recognize and did take that into consideration when making these offers to each one of the co-defendants. I certainly, in the pre-sentence investigation, believe that Mr. Goodwin is remorseful, and that it's interesting with younger defendants that I have found that most of them have been very honest about what happened during this transaction and their kind of individual responsibilities in all of this. So I do believe that Mr. Goodwin is remorseful. However, this crime was serious. It caused significant harm to these victims. The court has already, through the other 4 co-defendants, been able to read the victim impact statements and heard the state's arguments regarding the lasting effects that this has had, especially on the female victim. She was suffering from headaches, from being hit in the head. She was having trouble sleeping. I believe that at one point she may have said something about having seizures or some other medical condition associated with this. I think the fear that these 2 people felt is always going to have a lasting effect in the form of some PTSD. Mr. Goodwin also has some significant aggravators by way of his criminal history. He has at least 2 prior adjudications for domestic battery, maybe 3. He, in one of those cases, it looks like had some trouble, like Mr. Bannick said, following authority and participating in the court's orders. He has a history of substance abuse, which is in violation of Indiana law each and every time that he used illegal substances, including alcohol, because he's under the age of 21. The state recognizes that he has some mental health issues and some diagnoses that probably need to be dealt with. As far as RWI, the state doesn't necessarily have an objection to him being placed in RWI. I'm not sure, based upon his substance abuse history, that he's going to be what they would consider high risk or high need. But if the court wants to order him into that program.
I don't know off the top of my head what RWI is, but I think it's work release, but I could be wrong.
Directly, the state doesn't have any objection to doing that. I think that probably all of these, I want to call them kids, although they're adults, all of these individuals probably have some significant substance abuse issues that led to the stupid decisions that they made during this incident. Based upon all of those factors, Your Honor, I believe that an aggravated sentence is appropriate and is asking, and the state is asking for the sentence that I previously mentioned. Thank you.
Thank you, Ms. Clays. Your turn, Mr. Goodwin. What do you want to tell me before you get sentenced?
Wherever I end up going, I want to try to make myself into a better man for the community and myself, and try to get through my substance and my sentence in a positive way, and try to get more than just what I earned in DOC. I'm trying to earn a lot of things down when I get to wherever I'm going, so I can be better for everybody else and myself.
Thank you, Mr. Goodwin. So I'm going to go through aggravators and mitigators in a moment, as I'm required to do before you get sentenced. But before I do that, I want to remind you, armed robbery is a very, very serious crime. And it's very personal. And in particular, your two victims were traumatized. And you're going to hear me talk about that as an aggravator, because it is. This went way beyond you placing them in fear. And the other thing that I note is, you know, as Mr. Bannock pointed out, you're 18 years old. That's a huge mitigator. And this is your first felony conviction. Now, I'm going to tell you what I told some of your co-defendants. Boy, you picked a whopper of a first felony. I mean, the only way, in my mind, this could have gotten worse, as you told Mr. Bannock, if somebody pulled that trigger and one of these two victims ended up dead. Or one of your co-defendants. You know, it's a drug transaction. You can't be sure who is going to get shot. Let's go through mitigators and aggravators. Mitigators, you've accepted responsibility for your two armed robbery crimes. That's a weighty mitigator in your favor. Your statements today certainly are mitigating. More importantly, everything Mr. Bannock argued on your behalf, and he argued very well, those were all mitigating statements. This is your first felony conviction as an adult. That's a mitigator. Your age, your young age of 18 years is a mitigator. I'm gonna phrase it this way. I agree with everything Mr. Bannock said, but I'm just gonna call, you had a troubled childhood. Your troubled childhood is a mitigating factor. Your mental health issues, a mitigating factor. Your addictions issues, a mitigating factor. You obtained your GED and completed a number of rehabilitative programs. That's a mitigating factor. And finally, I agree with Ms. Clays. I think you're remorseful for your actions. That's a mitigator. Now, the problem is the aggravators. And you have a number of those. So your prior criminal history of 5 juvenile adjudications. You were on juvenile probation when you committed these offenses. You violated juvenile probation 6 times, showing a disregard for law and society. As a supplemental factor, your IRAS score is moderate risk to reoffend. Here's where your addictions become aggravating. You used marijuana from age 13 until right before the robberies. You used Xanax and ecstasy. You used alcohol. Each use was a separate offense, showing a disregard for the law and society. Other forms of sanctions have not kept the defendant from committing new criminal offenses. You have not taken advantage of programming and alternative sanctions offered to you in the past. This is a reflection of your young age and how long you have been in the juvenile system and how many resources were provided to you in an effort to rehabilitate you, young man. And you listen to this list because you may win the race for the longest list of rehabilitative programs that you were provided. Probation, psychological assessment and follow-up treatment, Basher shelter care, individual and family therapy, parental participation petition, reasonable efforts and best interests, substance abuse evaluation, follow-up treatment, youth advocate program, court costs were waived, therapy through Keys, White's Residential, ROP Woodford Group Home, Juvenile Detention Center. You were made a ward of the Indiana Department of Correction, community service hours, New Hope program, home detention, electronic monitoring, Oak Lawn, moral recognition therapy, suspended Indiana Department of Correction commitments, and juvenile adjudications. Here's where it gets much more personal, these aggravators, and these are all very heavy. You and your co-defendants used a scheme of deception to commit the armed robberies. The victim was seriously injured, which is not an element of the crime of armed robbery. The victim was traumatized beyond the element of fear in armed robbery. The victim was traumatized and had a life exchange or changing experience as a result of your armed robberies. All of those are very, very heavy aggravators. Court finds the aggravators take an individual or as a whole outweighing mitigating factors and an enhanced sentence is appropriate. Court further finds that counts 1 and 2 shall run consecutive based on the aggravating circumstances. So Caleb D. Goodwin, I sentence you on count 1, armed robbery, a level 3 felony, to the advisory sentence of 9 years. And enhance that sentence by 1 year for the aggravating circumstances for a total of 10 years at the Indiana Department of Correction. Pursuant to the plea bargain agreement, 3 years are suspended and you shall serve 3 years on probation at a level to be determined by probation. You're ordered to report to probation within 3 business days after your release from custody. On count 2, armed robbery, a level 3 felony. Again, I sentence you to the advisory sentence of 9 years at the Indiana Department of Correction, which I enhanced by 1 year for aggravating circumstances for a total of 10 years at the Indiana Department of Correction. Pursuant to the plea bargain agreement, I suspend 3 years and place you on probation, a level to be determined by probation for 3 years. Again, you're to report to probation within 3 business days of your release from custody. Counts 1 and 2 shall be served consecutively. I order you to pay court costs. I fine you $7,000 on each count and order that the fine be suspended.
This guy, he's out of suit too.
You're ordered to pay restitution to Sean Nast in the amount of $110. I find that you will not be indigent because you're going to be employed when you're on probation. I'm advising you the law does not allow, and this court will not incarcerate you for failure to pay fines and costs if you're indigent. I order you to provide a DNA sample at your cost pursuant to statute if you've not already done so. I order you to have addictions evaluation and also a mental health evaluation and to follow up with any recommended treatment. I give you credit for having served 14 days in actual custody plus good time credit for statute. The sentence in this case is consecutive to your sentence in 20 CO1 2002 JD 53. Your bond is released. The appearance of attorney Michael Bannick is ordered withdrawn. The order of commitment is entered. You're remanded to the custody of the sheriff to carry out this sentence. Mark this cause coming on for sentencing. Defendant appears in person from the Elkhart County Correctional Facility via WebEx and by his attorney, Michael Bannick. State of Indiana in court by Deputy Prosecuting Attorney Attorneys Kathleen Clays and Lucas Shoemate. The pre-sentence investigation report is approved as filed. Court hears arguments from counsel. Court hears a statement from the defendant. Defendant now sentenced on count 1, armed robbery, a level 3 felony to the advisory sentence of 9 years, which the court enhances by 1 year for aggravating circumstances for a total of 10 years to the Indiana Department of Correction. Pursuant to the plea bargain agreement, 3 years are suspended and the defendant is placed on 3 years of probation, a level to be determined by probation. As to count 2, armed robbery, a level 3 felony, the defendant is sentenced to the advisory sentence of 9 years, which the court enhances by 1 year for aggravating circumstances for a total of 10 years at the Indiana Department of Correction. Pursuant to the plea bargain agreement, 3 years are suspended. The defendant is placed on probation at a level to be determined by probation for 3 years. Excuse me. Defendant is ordered to report to probation within 3 business days after his release from custody. Counts 1 and 2 shall be served consecutively. Therefore, your total sentence is 20 years to the Indiana Department of Correction with 6 years suspended and 6 years on probation at a level to be determined by probation. Defendant given credit for having served 14 days in actual custody plus good time credit for statute. The sentence in this case is consecutive to 20 CO1 2002 JD 53. Your bond is released. The appearance of Mr. Bannick is ordered withdrawn, and the order of commitment is entered, and you are remanded to the Elkhart County Sheriff to carry out this sentence. Mr. Goodwin, listen to me carefully. You are young. You get down to the Indiana Department of Correction, continue your rehabilitation, okay? Continue your rehabilitation. I cannot guarantee you that you will get a modification, but you're young. Continue to rehabilitate yourself, and I can tell you I will consider a modification. I did not put you in recovery while incarcerated right now. Let's see if you get into that program on your own. I just sense you may not qualify. We'll see, okay? Good luck to you.
Thank you.
So I was wrong. It's not work release. It's recovery while incarcerated. I guess it's drug treatment. He does not qualify. I think he does not qualify because he doesn't have a drug addiction. I think he just wanted to rob them. I'll step on my keyboard. So I didn't watch any further than that. So I don't know what comes next, but the stream I don't have anything ready for today. I thought the trial was going to take longer. Anyway, we'll just watch Cristofino. Pause this. Hold on. 26 minutes. We are 26. Pity pie. You got to go. There we go. Hold on. I think I do have something else. Just give me 1 second to peek.
You won't consider another order?
I've considered it and I've denied that request. I don't think it's appropriate.
What? I don't understand why you don't think it's appropriate, just because I got 2 pending cases?
The 2 pending cases, the 20 past failures to appear. Yes,
How long ago was that?
I've already gone
How
over
long
it.
ago those failure to appears?
1 in 2024 and the remainder 19 in 2013 and beyond.
Okay, that's the past. Look what I've done so far.
That is one reason why I've lowered your bond.
What, only $1,000? There's no way I can come up with that, sir. There's no way, there's absolutely no way I can come up with that. I have nobody.
I understand, Mr.
There's
Christian. You're not helping your case by continuing to argue with me.
I mean,
That's
there's
the information. You have your information now. The jail staff will provide you Mr. Ariano's contact information. He can make an appropriate motion if he wants to have the matter heard for a full bond reduction hearing, and we'll notify him of the appointment as well. Again, do you have any questions over the information we've covered?
no, I would like to change the venue. I want.
Fine. Judge. Okay, so what we're going to do with, hold on, I have it ready. I do have it ready. Where the heck did it go? Oh, I had a link to Judge Fleischer's, hold on. I'll go into Discord real quick. So about the billboard, nobody posted anything in the GoFundMe. Like I asked, just making a decision on what we're going to do about the billboard. So this is what we're going to do about the billboard. No billboard. I mean, he can buy a billboard. This is how you support Judge Fleischer. If you want to support Judge Fleischer in his upcoming campaign to get reelected, it's in Discord. It's under the GoFundMe channel. Go here and donate. This is where you send money. Absolutely, under no circumstances should you send money to my YouTube channel, because YouTube steals that all. YouTube does not give that to me. YouTube takes a whole lot of it. Send it there to support Judge Fleischer's upcoming campaign. Y'all pledged. So it's the honor system. Yeah. And we, show him some love. You don't have to if it's not comfortable for you to do so, but we want him there for 4 more years. Texas needs him. We all need him. So if you have any questions, put it in Discord. All right, back to this guy.
Well, change venue right now. This is.
Make that request for you.
I'm making that request. I don't need Mr. Ariano to do that. I can make that request myself, and I'm making that request right now.
You're not
Because
entitled
it-
to
because
represent
you're-
yourself and have an attorney representing you. I've appointed Mr. Ariano
But
to
still-
represent you.
But
So-
still, I can make that request.
He will need to make the formal request to the court.
And then I'll make when I was in front of you with the eviction, that you had, I will do what I say. I will file.
I'm sorry. I just coughed. I don't think so. I think you're fine.
Everything for you being biased. Plain and simple.
All right. Thank you, Mr. Pittman. Have a seat in the back.
I won't have no issue.
Mr. Stackhouse, come on up to the front, sir. Thank you, ma'am.
I don't think Mr. Stackhouse is interesting.
This is cause number 203-240-996-2209. Is it Davion or Davion? How do you say your first name?
Want to know why I'm keeping it on? Even though I don't think it's interesting? Because his name is Stackhouse. Has anybody seen True Blood? Yeah, Jason.
It's Davion, sir.
Davion Stackhouse. He's present with us in court via the jail video. Mr. Stackhouse, I think the jail staff just provided you some paperwork regarding your case. That should be the information as well as the initial hearing order that we talked about earlier. I placed you under oath earlier as well. Could you please state your full name?
Davion Jason Stackhouse.
What's your date of birth?
February 18th, 1999 to 1899.
What are the last four digits of your social security number?
4911.
What would your address be if you were to be released?
1600 Sunset Avenue. That's Waukegan, Illinois. If you need help spelling Waukegan, I can spell it out for you.
I think we know how to spell that. What's the zip code there, though?
60087.
Thank you, sir. Do you have a phone number we can reach you at?
Yes, I do. It's 224-469-5047.
And finally, do you have an email address we can make a part of the court file?
Yes, it's Davion, Davion Stack Stack 1999-1999
Thank you. I appreciate you spelling it out as well. Do you have a copy of the information in front of you, sir?
Yes, I do.
It outlines 4 counts dating to August 23rd, 2024 here in Marshall County, state of Indiana. Count 1 is charged as resisting law enforcement, a level 6 felony, where it's alleged that you did knowingly flee from an Alex Trudy, a law enforcement officer, after said officer identified himself by visible or audible means and visibly or audibly ordered you to stop. And in committing said act, it's alleged that you used a vehicle. Count 2 is charged as resisting law enforcement, a class A misdemeanor, where it's alleged that you did knowingly flee from Alex Trudy, a law enforcement officer, after said officer identified himself by visible or audible means and visibly or audibly ordered you to stop. Count 3 is charged as possession of marijuana as a class B misdemeanor, where it's alleged that you did knowingly or intentionally possess marijuana, pure or adulterated. And count 4 is charged as unauthorized entry of a motor vehicle, a class B misdemeanor, where it's alleged that you did enter the motor vehicle of Jeffrey Benall, to it a blue Hyundai, Elantra, knowing that you did not have permission of that Jeffrey Benall to enter said vehicle, and it's alleged that you did not have a contractual interest in said vehicle. Mr. Stackhouse, I'm not asking that you agree or disagree, but do you understand what is being alleged?
Yes, Your Honor, I do.
In regard to the rights that I outlined earlier, did you hear and understand those rights?
Yes, Your Honor, I did.
Do you have any questions over them?
No, Your Honor, I don't.
Did you have an opportunity to review the range of penalty for the level 6 felony, the class A misdemeanor, and the class B misdemeanor for which you're charged?
Yes, Your Honor, I did.
Do you have any questions over that range of penalty?
No, Your Honor, I don't.
In regard to your attorney status, you posted a bond some time ago, and that was $1,500. That still stands as an asset that you can use to hire an attorney. And so are you planning on hiring an attorney or asking for a public defender, or what is your plan regarding attorney representation?
I would probably go with the public defender.
when I say that you've posted a bond, what I mean by that is we have a $1,500 bond held in our clerk's office. You could use that money to hire an attorney. And so that stands as an asset that you have that you can pay for the attorney of your own choosing. And so if you would want to hire an attorney, you can have that $1,500. I don't physically release that to you to go hire the attorney. The attorney receives that money directly. So with that, hopefully that's a better explanation of the fact that you have that money. My whole point in saying that also is generally I don't appoint public defenders on individuals that have posted a bond. But I make exceptions from time to time. Let me ask it in this way. Have you spoke to any attorneys?
No, I haven't.
And are you wanting some time to try to hire an attorney, or not speaking to an attorney, you don't really know what they're going to charge. And so the 1,500 may be appropriate for this type of case.
Okay.
So
Well, yeah,
what is your decision then?
Yeah, I would like to use the 1,500 towards an attorney then.
For the jail staff, do you have a listing of the local attorneys at the jail? I know we have it here in the courtroom, but I wasn't sure if.
Yes, sir. I do.
Could you give a copy of that to Mr. Stackhouse just for his information?
Can you have your bailiff send another roster of that, because that's the last one I have. I'm gonna try
Yes.
to print out some more if possible.
Yeah, she'll send you the most up-to-date one.
Awesome. Thank you.
Thank you, sir. Mr. Stackhouse, what was just provided to you is just a listing of local attorneys. You're under no obligation to hire any specific one of them, but that's a resource for you to look at and then maybe make phone calls and see what they would charge you. What I'm going to do is just make a determination that you are planning on hiring your own counsel, plan on using the bond money. And when you speak to the attorneys about representing you, let them know you posted the $1,500 previously. If you're making phone calls from the jail, they may be confused on why you're calling from the jail, but yet you say you posted a bond and there's this intervening failure to appear, which I'm going to address with you, but that's why you're incarcerated currently. So make sure you kind of outline some of those details for the attorneys, and it'll help your discussions with them moving forward. As it relates to the hearing dates, I already mentioned the pretrial conference of June 18th, 2025 at 9 a.m. If you are released and do not have an attorney representing you, you must be physically present in court with me. If you are still incarcerated and either there's an attorney representing you, we'll do that hearing without you. If there is not an attorney representing you by that pretrial conference, then we'll bring you up via the jail video. Now, the status hearing is going to be scheduled for August 14th, 2025. That'll be at 8:15 if you're incarcerated and at 9 o'clock if you're released. And plan on being here at that status hearing, regardless of what's occurring in the case and regardless of your attorney representation. Any questions over those hearing dates?
No, Your Honor, I don't know.
I'm going to schedule one other hearing date for you, sir, and that is going to be a status of counsel hearing. And that status of counsel hearing is for the purpose of checking up on your attorney status of whether you've hired an attorney. That status of counsel hearing will be May 30th, 2025 at 8:15. If you're still incarcerated and have not hired an attorney, then we will have that status of counsel hearing. If you have been released on bond, or if you are incarcerated and have hired an attorney, then we will not have that hearing. So the only time we will have that hearing is if you're incarcerated still and have not hired an attorney. And then I can check back on your efforts to hire an attorney or whether you need to ask for a public defender at that time.
Okay.
Final detail about your case this morning is that you had previously posted that bond of $1,500. When you did so, there was a promise to appear that was signed for you to be here September 24th, 2024 at 8:30. September 24th came, you were not here. The court noted your failure to appear and issued a warrant for your arrest. That warrant was served upon you recently, and that's why you find yourself in jail. You're currently held without bond because of the failure to appear. The pretrial release recommendation notes the out-of-state residence as well as the one past failure to appear for this case that we just referenced. And it notes that you're disqualified because you are held on the failure to appear, and it also notes that you were extradited from Illinois. So, Mr. Stackhouse, where were you September 24th when we tried to do an initial hearing in this case?
I got picked up from the prison in Illinois. I was on parole at the time of the offense. I just finished my parole time, so I'm not currently dealing with parole anymore or any type of supervision anywhere else or any other cases anywhere else. So now that I got that all cleared up.
Seems like I had the tab open for Warren County, Ohio, and we're picking that up in the background. Hopefully it doesn't get annoying and we can hear the end of this. We'll see.
I could continue to move forward
All right,
without any issues.
this is case number
What I'm hearing is you were released here in August of 2024 and had to serve time in Illinois for a parole violation. Is that correct?
Yes.
And then were you transferred from that incarceration in Illinois directly to Marshall County?
Yes, I was. Actually, Kane picked me up.
Drove 5.5 hours.
Go ahead, sir. What was
Yeah.
that?
Ms. Gaines, anything you want to add?
Well, I didn't hear that. What was that?
I drove 5.5 hours there and back to go get him. He was about an hour and 15 minutes southeast of St. Louis, Missouri.
Well, certainly I appreciate your time and effort and expense of going to retrieve Mr. Stackhouse. I do appreciate also the information of how you find yourself here in the Marshall County Jail. And Mr. Stackhouse, what I am looking at is setting a bond for you because I don't believe releasing you without some sort of further bond is appropriate. I understand why you were not here at that failure to appear in September, but your out-of-state residence is alone enough for me to set some sort of bond to make sure you come back and try to retain that asset or have that asset back at the conclusion of the case. If I were to release you without any further bond, I have concern about you coming back simply because of your out-of-state residence.
Well, I will promise and confirm to you, Judge, that is not going to be the issue. I don't care if I have to come up here 3 days prior to make sure that I show up on time at the June 18th court date or the 5/30/25 status hearing. I will be I will make sure I'm present in your courtroom every time that I have a court date. I got a child on the way right now. He's going to be born soon. It's my first child. I really do need to get back out there and help my girl out and be present in my son's life. You have no worries about me coming to court. That's the least of your concern. I guarantee you that I will show up. And if you need me to, I could provide documentation, ultrasounds, doctor's appointment visits, whatever documentation I need to prove that I actually do have a son on the way.
Well, I'm not disputing that, Mr. Stackhouse, and I'm just thinking you have a lot of good reasons to face responsibility for your cases, make sure they're resolved in some way, taking them to final disposition, appearing at future hearing dates, because just not drawing any conclusions about this, but it sounds as though you've had some prior cases where you had to serve executed time, and that will disrupt your lifestyle substantially. And so you've learned that lesson, it sounds like, but I still think that some amount of bond, in addition to the $1,500, is appropriate to make sure that you come back to get this case to disposition. What I'm looking at is a modest bond, not something that is a sizable amount for you, but something to show the court that you are serious about your taking this to final disposition, appearing at future hearing dates. So what I'm looking at setting is a bond of $500, and that way you can post that bond, you can be released, and then if you do, you can come back to the hearing dates I've scheduled.
Banks, is there anything you'd like to add?
You understand that's what the court's setting the bond at?
Yes, Your Honor, I do.
Do you think you'll be able to post that?
Yes, I should.
If you post that, make sure you're here at the future hearing dates. Specifically,
Okay, good enough. We got to the end. We got to the $500 bond before the other court intruded so rudely. Remember, CJ, I just said a minute ago that Warren County was opening another tab. Warren County, Ohio was opening another tab. I paused the video and I said, you're going to hear voices, but hopefully we can make it to the end. And we made it to the end. So let's see if Georgia has something interesting for us. That's hair. That's a lot of hair. Look at that. Let's watch her. I could tell. Oh, no, he has her muted, I think. Yep. He won't let us hear her. He muted her.
To force you to
Not him.
Mr. Mark, pronounce your first name for me, sir.
Marquise.
Marquise.
This is,
Mathis. It
This is, if I had a guess, hold on. Let me look at my list real quick. This is, no, I think it's Dodge County courtroom. I think. It could be Telfair, but I think it's Dodge County.
is case number 23R2930. Oh, let me get that one added on. R2930. All right, I'll note for the record that Mr. Mathis is standing at the podium with his attorney, Mr. Stuart Deal. I have been handed a plea sheet. Mr. Deal, you've got a plea recommendation to make, sir?
We do, Your Honor.
Go ahead.
It will be a plea to count one as alleged, third paragraph. It'll be 3 years probation, $500 fine. This will be subject to the standard drug and alcohol conditions with Fourth Amendment waiver. The restitution will remain open for 90 days.
Anything to add from the state?
No, Your Honor, that's correct.
And count one is forgery in the third degree. All right. And it's 1 to 5. Is that correct, Mr. Deal?
Yes, Your Honor.
All right, Mr. Mathis, it appears that you and Mr. Deal in the DA's office have been discussing your case and have reached this joint recommendation, or a negotiated plea, as we call it. I'm going to have a lot of questions for you in just a moment, but so far, has everyone said what you expected them to say?
Yes, sir.
Before I can get to the disposition phase of your case, I have to first go through a process with you where I ask you a series of questions to make sure that you understand all the details of this plea, but just as important, that you understand all of the rights that you'll be giving up if you make sure that you agreement today. If at any point during this process you don't understand my questions, or you need some more time to talk to Mr. Deal, just let me know, and I'll give you all the time that you need within reason. Do you understand everything so far, Mr. Mathis?
Yes, sir.
As best you're able, please raise your right hand. Do you swear or affirm under penalty of perjury that the testimony you give here today shall be the truth?
Yes, sir.
You put your hand down. Mr. Mathis, do you understand that you were pleading guilty to count 1 under the First Offender Act?
Yes, sir.
And the sentence recommendation is 3 years probation, a fine, and all these other conditions. Do you understand that, Mr. Mathis?
Yes.
And is that what you agreed to plead guilty to under the First Offender Act before you came up here to the podium?
Yes.
Before the court can decide or determine whether or not to accept this recommendation and this plea, the court must first determine that you are making a knowing, intelligent, and voluntary waiver of all of your rights, that you know and understand what you're doing, and that you're doing it of your own free will. So it's vitally important that you speak up if something happens that you don't understand. According to the plea agreement, we're going to focus on count 1, which is forgery in the 3rd degree. It is a felony. It has a maximum sentence of 5 years to serve in prison, with a sentence range of 1 to 5 years to serve in prison. Now, that's important for lots of reasons, but one of which is Mr. Deal indicates you wish to make this plea under the First Offender Act. The court does advise you that if a first offender probationer violates the terms of this probation and the court later enters an adjudication of guilty, the court may then impose any sentence permitted by law for the said offense you're about to plead guilty to at a probation revocation and adjudication of guilty hearing. A first offender probationer may then be resentenced to a sentence greater than what you get here today, up to the maximum amount allowed by law that I just described to you. Do you understand that, Mr. Mathis?
Yes, sir.
And you still wish to proceed with a First Offender Act plea, is that correct, sir?
Yes.
Court does further advise you that you cannot be forced or compelled to enter a guilty plea today. You can maintain your not guilty plea and have a speedy and public jury trial if that's what you wanted, where you would enjoy a presumption of innocence that would remain with you throughout the trial, and the state would have the burden of proving your guilt to the satisfaction of the jury beyond a reasonable doubt. You would have the right to be represented by your lawyer at all stages of the trial. And if you could not afford a lawyer, then the court would appoint a lawyer to represent you for the trial. In the trial, you would have the right to confront, question, and cross-examine all witnesses and persons who accuse you. You'd have the right to defend yourself and to bring into court your own witnesses and evidence in your behalf. And at your request, the court would issue subpoenas directed to your witnesses to compel them to come to court. You would have the right to testify in your own behalf, but you could not be compelled to testify nor to incriminate yourself, because you have the right to be present throughout the trial, including the right to be present and remain silent. You would also have the right to ask the court to suppress any illegally obtained evidence, and if the jury should find you guilty, you would have the right to appeal that guilty finding to a higher court, and that would include the right to be represented on that appeal by either your court-appointed attorney or private retained attorney, as the case might be. Mr. Mathis, do you understand that if you plead guilty today pursuant to this plea agreement, you will be giving up or waiving all of these rights that I've just explained to you for this case? Do you understand that?
Yes, sir.
Fourth Amendment waiver will be a condition of this probation. Do you agree and understand that it's a special condition?
He is not a new judge, but he's a judge you will only see here on this channel.
Of probation will be that you shall submit to a search of your person and property at any time of the day or night, with or without your consent or a search warrant, whenever requested to do so by a probation officer or a law enforcement officer. And if anything is taken, it may be used against you as evidence in a further court proceeding. Do you understand that?
Yes.
Now, you're represented here today by Mr. Deal, is that correct?
Yes.
Have you had enough time to talk to Mr. Deal about this case?
Yes, sir.
Do you need any more time to talk to Mr. Deal about this case?
No, sir.
Do you have any objections whatsoever about how Mr. Deal has handled your case?
No, sir.
Is this your free and voluntary plea?
Yes, sir.
Has anyone threatened you or frightened you to force you to plead guilty?
No.
Other than the plea recommendation, has anyone promised you anything to get you to plead guilty? Are you under the
If you hear July while you're watching a court video, chances are you're only going to see that here.
Influence today of any intoxicants like alcohol, drugs, narcotics, or prescription medications?
No, sir.
Is your mind clear today?
Yes, sir.
Do you know where you are and what you were doing?
Yes, sir.
Do you have any questions about anything that has happened up to this point?
No, sir.
If you are not a United States citizen, a guilty plea will affect your immigration status. Mr. Mathis, are you pleading to count 1, forgery in the 3rd degree under the First Offender Act because you are in fact guilty?
Yes.
All right, Mr. Deal, so this plea gets entered.
Am I the only one who loves it when Terry says hi to Terry? So Kathy is a common name. It's a common name. However, there's different ways to spell it, but the main two are with a C or a K. Kathy with a C or Kathy with a K. I know you can spell it with I's, and the main two ways to spell Kathy is Cathy and Kathy. And when I meet other Kathys, it's always the same thing. You know, is that a K or a C? No, K. Oh, you're a K. You're one of those. I'm a C. Or the same way. Oh, you're a K. Me too. Let's go. I always spell Nan the same way, but sometimes I spell it backward. I've never watched 1 minute of the Karen Reed trial ever. Not one. I don't even know what it is. I know it's important. Everybody's talking
Very well.
about it.
Anything from the defense?
Your Honor, we would just ask that the bench warrant in this case be lifted since the resolved case now to accept the sentence.
Kathleen.
Mr. Mathis, do you have any questions about anything that has happened up to this point?
No, sir.
Is there anything that you would like to say? You don't have to, but you can if you want to.
No, sir.
Very well. The court finds that the plea has been freely and voluntarily entered. There is a factual basis for the plea, and the court will accept the stipulation and the recommendation as was stated. Count 1, 3 years on probation under the First Offender Act, $500 fine plus the add-ons that go with it, drug and alcohol, and Fourth Amendment waiver conditions. You have a period of 4 years to file a habeas corpus petition from the date the sentence becomes final, 30 days to file a notice of appeal or a motion for new trial. Do you possess a concealed carry permit for a firearm, Mr. Mathis?
No, sir.
All right, that will conclude your case. Somebody from probation will catch up to you, Mr. Mathis, first chance they get, but that will conclude this case. Good luck to you, sir. Is that everyone from the back? It is? All right. Well, the jail is excused. Thank you.
My maiden name was Kelly with a Y.
We'll be back.
No, Judge.
Take care of
Judge.
what
All right, he's taking a short break, and then we'll be back to take care of something. Let's take care of this. I hope it's good. That's not a short break, Judge. You lied. Contempt of court. Oh my gosh. Watch, he probably doesn't come back. There it goes. That was not a short break. It's muted. Calm down. It's muted. This judge likes to mute. There we
All
go.
right, let's get on the record here. Going to call it this time, case number 18R0460, State versus Michael Logan Phillips. That's you, sir? You're Mr. Phillips?
Yes, I said that. Yes, sir.
All right, Mr. Phillips is present in the courtroom, seated at the council table with his attorney, Mr. Harrington. This matter is scheduled today.
We need the rain for the
Pre-trial
fall and the veggies.
preliminary motions, and I'll get into that if we need to. But I want to get on the record a couple of things. After a very long chambers conference with the assistant DAs, Ms. Adams and Ms. Lowry, and defense counsel, Mr. Harrington and Mr. McLaughlin representing the co-defendant, there are some evidentiary issues that, well, to say they're convoluted would be an understatement, but that have caused the court to have some serious concerns about whether or how to proceed. So it is I don't really want to throw it wide open, but is there any additional statements that any counsel cares to make, or any objections to what we discussed in chambers, which is to hopefully reschedule this thing? I got to talk to Judge Caulfield to see if we can shuffle around a trial week, but we're talking about June the 9th. But is there any objection to that from the state?
No, Judge.
Mr. Harrington?
That's so cool, CJ.
Standing, Your Honor, I forgot to check my calendar. If you can get me out of Creston, Truton County, and since this is criminal and jury trial, it should take precedence, but those are the only things I have scheduled that week.
What, you have criminal cases in other counties?
No, the other two are civil matters.
Oh, okay, no worries.
So I don't think that's a problem.
I'll handle that.
Plus, this is much older in time.
Absolutely.
Your Honor, I'm always.
I desperately want to know what it is, but I don't know if I can pronounce it.
I can't 100% commit to June the 9th. Not yet. I got to talk to Judge Caulfield and let's make sure that we're all going to get clear, but I'll know later today and I'll get an email out in another order setting it down for the 9th, and I'll check if, see if a jury has been summoned yet already for the. Okay, do you?
And I've already sent notices.
Right. Right. That's what I'm talking about. Okay, but I got to see what he's got. And do you know, was it for Monday or Tuesday? Okay. Well, we'll figure it out later. That's just a detail. We'll figure it out later. All right. Anything else either side wants to get on the record? All right. Well, we're going to pump this one down the road to the 9th. And if these evidentiary issues come up, or when you get some more information about these evidentiary issues, let me know. And if we need to get back together, we will. I just don't know when. But all right. Anything else?
No, Judge, we'll keep you updated.
Okay, Mr. Daniels, come back up. Mr. Harrington, you and your client. Anything else, Mr. Harrington?
No, sure, although I will agree.
Tig. His name is Tig.
Before we approach the jury.
All right. Well, you and Mr. Phillips are excused until the 9th or whatever day I put on the notice. All right, Mr. Daniels, let me get back to your case here. All right, on spikes. Well, I know the state has been busting it to get ready on the Phillips case, and I think one of you told me the witnesses are not available.
That's right, Judge.
Okay.
Due to him being held in Lawrence County without a bond.
All right, well, I don't have any, that one's not so old. I'm not so worried about it. Any objection to a continuance on this one, Mr. Daniels? All right, very good. I don't know when it'll be, but you'll get a notice.
Thank you, Judge.
All right, yes, sir. You are excused, Mr. Daniels. Thank you, sir.
Check on.
And that's it, right?
Do I have Kevin Helgeson? Are you Kevin Helgeson? All right, thank you. You're here on case 25 FE009990.
I don't know what this is. I'm just checking. This is what I got yesterday. This happened yesterday, but I don't know. Hold on. I have to fast forward it because this. And that's what I was afraid of. It stops right in the middle of this one. So we're not going to be able to listen to this one. And this one looks the most interesting out of all of them. This is California. We're just going to listen for a couple minutes and then we'll be good to go.
Do I have Kevin Helgeson?
I'm good on this.
Are you Kevin Helgeson? All right, thank you. You're here on case 25 FE 009904. The alleged offense dates October 22nd, 2023. Count one alleges burglary under Penal Code 459. The public defender is appointed.
Formally invited the right at this time. Your Honor, I'm in possession of discovery intent, maybe briefly can.
Yes.
Page 27.
This is another judge and another courtroom you only find on this channel. And I'm guessing that the other judge is gone. Remember, I loved her. The other lady that was here, can't remember her name, but she was so forceful. And I haven't seen her in a while. I only see this guy.
Do I have Andrew Kowalski? Are you Andrew Kowalski?
Yeah.
Thank you. You are here on case 25 FE 009936, alleged offense date of March 26, 2025. Count one alleges burglary under Penal Code 459. The public defender is appointed.
I also have I can't remember which county, another cage in California, another courtroom with a cage, but the audio is so wretched, but they have the craziest people in there. I want to get them more, but the audio, I mean, if you watched my channel, you've seen it before. You only see it here, probably because the audio is so terrible and other people won't play it.
We can come back for Mr. Kowalski on May 29th, please.
All right, the next court date will be May 29th, 8:30, Department 63 for further pretrial release hearing. That'll be the order.
All right, recalling page 22, Augustin.
All right.
Your Honor, this is not one we raised during the pre-court conference. We only just now noticed that the offense date is 10/22/23. That appears to predate his other cases. So this is not a failure to comply with pre-trial release like we thought. So I do think in light of that, this is when we would like to address pre-trial release if possible, Your Honor.
All right, I don't believe I had a packet on this. Is there any way to get a packet from Mr. Helgeson?
Judge, I believe he's in custody on his VOP ending 8682, and that's why there's no packet.
Can we check whether he is being held in custody on some other matter?
He has two VOPs set for June 25th.
Excuse me.
Oh.
Never mind.
Never mind then. All right.
None of that, Your Honor. Your Honor, the reason why I have this joint other matters on 6/25/25 at 1:30 Department 4.
All right, the next court date will be June 25th, 1:30, Department 4. That'll be the order. Thank you, Mr. Helgeson. You're welcome.
13/14 Damiano with a dollar sentence 60.
All right, pages 13 and 14, Joanna Damiano was dropped from the calendar and sent to Department 60.
Yes.
Under Penal Code 270-99.
46 Norado.
Do I have Gabriel Gustavo Narado? Thank you. You are here on case 25 MI 009903. The alleged offense date is May 20th, 2025. Count one alleges a willful and knowing violation of a court order under Penal Code 273.6A. Count two alleges vandalism under Penal Code 594A. You also have an out-of-county warrant from Los Angeles for $30,000. At this time, the public defender is appointed.
Yes, Your Honor, I would record accepting appointment, waiving formal arraignment and inviting the rights at this time. I'm not yet in possession of the discovery on this matter. Your Honor, pursuant to our pre-court conference earlier this afternoon, I'm requesting that Mr. Narado can receive some general competence and made available for that warrant, and then we come back on June 30th, 2025 at 8:30 in Department 1.
I'm objecting, asking he remain detained. I'm concerned he's a flight risk and that he will not abide by the court's orders. He's here on a 273.6 594 misdemeanor matter. He does have an out-of-county warrant, as the court is aware. And so that is problematic in conjunction with the facts of this case. He is violating an order that was served on the same day. He was served with this order that protects his grandmother. He returned 30 minutes later. He attempted to get into the home, damaged the door by pulling on it. My concern is for her safety, that he's not following a protective order that was put in place and he was served with, and that he has the out-of-county warrant. So I'm asking he remain detained.
Thank you, Ms. Scalata. Sir, I am going to release you on your own recognizance, but subject to conditions. Ms. Scalata, could you tell me the address again for the stay away? Understand
Yes.
over the people's objection.
Yes, and I have provided a no contact order for the court, and it has the address listed on that no contact order, but I can provide it again. It's 877 Eleanor Avenue.
Okay. All right, we'll have that order in a moment. This is the Narado case. Okay, thank you. All right, here we are. All right, so sir, as I said, I will release you on your own recognizance, but you are ordered to stay at least 100 yards away from and not contact Donna Lawrence, and you are also ordered to stay at least 100 yards away from the address at 877 Eleanor Avenue, Sacramento, California. Those are conditions of your release. Do you understand and accept them? Okay. The next court date will be June 30th, 8:30 in Department 1. You must stay in touch with your lawyer. And then the last thing is I have been provided with a criminal protective order from the people. I am signing it now. All right, here are 2 copies for stamping and service. All right, Mr. Narado, you're going to be served a copy of this order. It's important that you keep it and that you understand what's in it, because if you don't follow it, you can be subject to additional criminal charges. In this order, I want to highlight 2 aspects. You must not contact Donna Lawrence directly or indirectly in any way. You must stay at least 100 yards away from them, their home, job, workplace, vehicle, and that address I told you earlier. Once that order has been served, that will complete the court date.
Page 32 middle. Review course.
Mr. Narado was served. All right, thank you, sir. Bobby Jean Little refused court. Could we check which refusal this is? Which number? Is it the 3rd? Okay, so we're going to continue this case to May 23rd, tomorrow at 3 p.m. in Department 62. I find good cause to do so, and I will, let's prepare an extraction order for tomorrow.
Page 2, all of it.
All right, Michael Shane Aldred's appearance waived. The public defender is appointed.
Return June 30th, 8:30 Department.
All right, he'll be released on his own recognizance after the parole hold lifts. The next court date will be June 30th, 8:30 in Department 1. That's the order.
Safety.
Do I have Landon Thornton? Hello, sir. You're here on case 25 MI 009907. The alleged offense dates May 20th, 2025. Count 1 alleges carrying a concealed dirk or dagger under Penal Code 21310. Count 2 alleges resisting arrest under Penal Code 148A1. You have a separate misdemeanor case set for trial on June 9th. And you have a $40,000 warrant for you out of Siskiyou County. The public defender is appointed.
Invited in right this time and not yet possession either discovered or complaint.
Yes.
Ask them 55, same.
All right. We're going to end it right there. Oh, thank you so much for coming out, guys. I appreciate it. Tomorrow we'll be back to small clips like this from different courtrooms. No more trials for a while. I love doing trials, but they take so long. These clips are, they take longer to get. Trials are easy. I just get one trial and I'm good for a while. No, thanks for coming out. I'm gonna pop us all over to OJ. Mark Furman is still on the stand, but Marsha Clark is questioning him, and it's direct examination, so it's not extremely exciting right now, other than the normal. So they break court a lot to do sidebars and bring up other. Yesterday, oh my God, I was so frustrated. I was so mad yesterday because the Dream Team broke the law again. I'm telling you, they broke the law again. But anyway, we're going to get back to that now. I'll see you guys later. Thanks.
Got these life that goes digital dreams through the screen, her blue eyes gleam. Wicked humor, sharp as a knife. Her stream sparks electric light. Late night when the world sleeps, she's the friend that always keeps. Giggles roll like thunder loud. She stands out in any crowd. Kathy's laugh cuts through the gloom. Eyes blue like a summer's bloom. Her humor dark and twisted sharp. In a way, there's no alarm. Freedom tales late into the night. Her laughter feels just right. Even when my world turns gray, with a giggle, she lights the way. Her eyes near a sky so blue. In her jokes, there's a truth so true. With extreme, she brings the light. Turns dark days into bright. Kathy's laugh cuts through the gloom. Eyes blue like a summer's bloom. Her humor dark and twisted sharp. In a way, there's no alarm. Streaming tales late into the night. Her laughter feels just right. Even when my world turns gray, with a giggle, she lights the way. Kathy's laugh